Dr. Foster, you still under oath?
Thank you, my lady.
Yes, Mr. Nel.
Please, the court, my lady. Doctor, you said yesterday that the GAD may have played a role in his actions on the morning of 14 February.
Yes.
Now, if that is so, then the GAD being a psychiatric disorder, what you're saying is that the psychiatric disorder played a role?
Yes.
May have played a role.
May have played a role.
Yeah. At the least, and that's just at the least, the way you indicated the purpose of your report is to put psychiatric factors before court.
Yes.
So at the least, it's a psychiatric factor, but you just said that a psychiatric disorder may have played a role.
And together with his vulnerability,
Yeah.
yes, that's
Yeah.
correct.
May have played a role. Now, the diagnosis of GAD, that's a psychiatric diagnosis and in the realm of experts.
Yes.
And you did that, not the diagnosis, but the fact that it may have played a role in line with his version only.
Yes.
And at this stage, as far as you're concerned, there's been no evaluation of his psychiatric condition, if I might call it that, in line with other versions before court.
No. His psychiatric condition will remain a constant, but it hasn't been applied to other versions.
Yeah,
correct.
Now, in more, I think we dealt with yesterday, and I just want to go there again. If one would say that GAD played a role, it was not so much in as far as his understanding of an act. No, it's not so much in terms of his understanding of what's right or wrong.
That's correct.
It's more in his ability to act in accordance with this understanding.
It could be.
Could be, yeah.
Yes.
Yeah. So it would not be, and you know the Act as well as I do, it's not in terms of 78.1, it would be in terms of 78.1b, not 1a, but 1b.
That's correct.
Now, from a psychiatric perspective, that's not a criminal law perspective, but from a psychiatric perspective, GAD is listed in the DSM-5.
As are many other
Yeah,
conditions.
yeah, most conditions.
All of
Would I
them.
say all of them? Yeah.
Yes.
As all of them. But GAD, the one that you diagnosed, is definitely one that has been diagnosed as such.
That's contained in the DSM-5.
Yeah.
Yes.
Yeah, contained. Yeah,
Yes.
I used it wrong.
That's right.
I'm looking for it, but perhaps you can help me. In the DSM, that would stand for
Diagnostic and Statistical Manual.
Of mental disorders.
Yes.
Okay. Now, so that would, from a psychiatric perspective, qualify as a mental disorder.
Yes. As all the others contained in there.
Yeah. No, that is true. Now, to make a diagnosis and how that impacted on a set of facts that is in the realm of experts.
To
Except
make a
the factual
psychiatric
finding.
diagnosis is correct.
Yeah.
So factual findings on the offence is the
In
realm
the-
of the court.
Well, that is correct. Thank you, my lady. I have nothing further.
Thank you. Yes, Mr.
Sorry
Kapoor.
to ask you to be up and down, but I just need about 10 minutes maximum. A short adjournment.
We'll adjourn for 10 minutes.
Item number 1.
You're still under oath, Dr. Foster.
Thank you, my lady.
Thank you.
Thank you, my lady. Dr. Foster, there was reference to DSM-5, and I think that we should put that in its proper context. It deals with disorders, and not only the present disorder. Is that correct?
The DSM-5, my lady, is a manual of mental disorder. It is a type of a classification system, and so it deals with all kinds of mental disorders. In fact, it's a comprehensive classification system of all mental disorders.
It also has a cautionary.
It has a cautionary statement right in the beginning against its forensic use.
Could you read that, what it says in the cautionary?
I'm reading from page 25. I don't have a copy.
We will make a copy available afterwards, if you can just read it.
Around the middle of the page, it says the use of DSM-5 should be informed by an awareness of the risks and limitations of its use in forensic setting. When DSM-5 categories, criteria and textual descriptions are employed for forensic purposes, there is a risk that diagnostic information will be misused or misunderstood. These dangers arise because of the imperfect fit between the questions of ultimate concern to the law and the information contained in a clinical diagnosis. In most situations, the clinical diagnosis of DSM-5 mental disorder, such as intellectual disability, schizophrenia, major cognitive disorder, gambling disorder, or pedophilic disorder, does not imply that an individual with such a condition meets legal criteria for the presence of a mental disorder or a specified legal standard. For the latter, additional information is usually required beyond that contained in the DSM-5 diagnosis, which may include information about the individual's functional impairment and how these impairments affect the particular abilities in question. It's particularly because impairments, abilities, and disabilities vary widely within each diagnostic category that assignment of a particular diagnosis does not imply a specific level of impairment or disability. That's just in that paragraph, it's the middle part. If that may be of use, my lady.
Doctor, then in relation to section 78, I want to put your evidence in proper context. I have a copy of the transcript. My lady, I only have one. I will make more copies available. It's just to follow what I'm referring to. And what I'm going to refer to, my lady, is page 3990. It's page 3990, my lady. That's just of the real-time transcript that I'm giving to my lady. You were asked whether you believed that your allegation is that he should be referred. And I want to read the answer and again given to you and then ask you about it. And you say, line 6, but generalized anxiety disorder is a psychiatric diagnosis. I would not consider it to be a mental illness as perceived in a Criminal Procedure Act, and so in my opinion it would not be something that can be taken into account in terms of looking at his responsibility as though it were mental illness. I think that what I'm trying to bring to the court's attention is his generalized anxiety disorder that would affect his reaction when placed in situations. So it is not as though he has a mental illness, that perhaps he had a delusion about people entering this house. I'm not saying that at all. So it's rather that being a mental illness, although it is a psychiatric diagnosis. What I'm saying, my lady, is that it's not a mental illness as considered in terms of the Criminal Procedure Act.
Yes,
Yes.
that is my opinion.
Yes.
If if one looks further at the Mental Health Act, for which maybe one could be declared an involuntary patient, this would not be a diagnosis that would render one as being in need of involuntary care or treatment. So while it is a psychiatric diagnosis, so are many other psychiatric diagnoses.
Doctor, maybe just your experience in regard to people referred to for 30-day observations. What is that? What is your experience?
Well, I have certainly seen many hundreds, if not thousands, of accused referred for observation. And in my opinion, if you have a diagnosis of a generalized anxiety disorder, which would be made, that would not render you unfit to stand trial or not able to appreciate the wrongfulness of your acts.
It would not be a Section 78.
Correct.
One and two there.
You would not be declared at the end of this, shall we say, as a state patient in need of involuntary care.
If you say you've seen hundreds, if not thousands, in what capacity?
As a psychiatrist.
Were you involved there?
Yes.
Employed as a state psychiatrist there?
Yes, as
Now, but what you constantly say when you say in your view it is not a case for Section 78. What you say, but of course it depends on the facts, what the court must find.
yes.
And you refer to two things in your evidence. The one is delusional and the one is paranoia.
Yes.
And you use the example to say, for instance, and I may use it, if his version is that I heard a window sliding open and the common cause facts are that the window was closed all the time, would that be a factor that you would take into account? More to delusional or paranoia?
Well, individuals who have a generalized anxiety disorder will wake up at night and hear noises that are maybe distant noises or something else entirely, and then think it may be a window being opened. That's not a delusion as such, but that's part of an anxiety. But if there was a delusion that people were generally trying to break into one's house in terms of a paranoid belief, yes, then certainly one would say, no, this person has lost touch with reality and should be referred for observation.
Yes, and I'm going to the specific facts that I want to deal with. His evidence was that he had a bathroom window sliding. The common cause facts are that photographs were taken and the window was in fact open. So it's not that the window was closed and he heard it opening. The second part is his evidence was he heard the toilet door slamming. The evidence was not that when he got there the toilet door was open.
Well, an anxious person who is concerned that there is an intruder in the house, who then hears a toilet door close, will become very fearful.
Yes, I understand that, but the point I'm trying to make is this, Doctor. It's not that we talk about the delusion here.
No.
In fact, the toilet door was closed and the window was open.
Yes, it's not in the realm of delusions at all.
Could you find delusion in this case and paranoia?
No, I looked for paranoia, but I didn't find it.
And my understanding is you don't want to compromise yourself on the facts. If the court's finding is different, that there was in fact this delusional reaction or a paranoia, then of course it would be or could be a section 78, and you would make that allegation.
It's always dependent on the court's decision.
But as you stand here, you don't make an allegation that he must be referred.
No.
Now, there was also a question put to you about him being a dangerous person, having regard to the disorder and a firearm. And you qualified it in cross-examination this morning, but I want to put a factual position to you. There was evidence of an incident where he was assaulted and he was hit from behind, and he needed medical attention, and he had his firearm and he did not use his firearm. What would you say about that?
Well, that shows he was able to maintain a sense of responsibility and not to use his firearm irresponsibly.
You also spoke about excessive measures taken by him in securing his safety.
Yes.
One thing you did not refer to, and I want to put it to you, that's part of the evidence. In addition to locking the door, he also placed his cricket bat between a cabinet and the door to prevent its opening.
Yes.
Would that support what you're saying, or would that not play a role?
No, it is supportive.
There was a reason for that, wasn't there? There was a reason for that.
Yes, ma'am.
Wasn't there?
My understanding of the reason he locked it and he put the bat there.
No. Wasn't there something wrong with the key mechanism?
Lady, I would have to look at it, and if I give you now an answer, I'm going to give the wrong answer. I will look it up and come back, and I will make a submission about that.
Yes, thank you.
About the broken glass, it's the evidence was because the lock mechanism of the door was not very strong. My lady, it's been pointed out. The lock mechanism was not strong.
Yes.
That's his evidence.
Thank you.
Not that it did not lock, it was just not a strong lock.
Thank you very much.
Now, take that into account. The lock mechanism was not strong. So in addition to locking it, he also put his bat.
Well, that would be an additional safety mechanism.
You were also asked about the broken glass. The evidence was that the contractor was at that time working on the house, repairing, and in fact, the replacement glass was in the house to be put in.
What do you mean broken glass?
At the bottom, it was with the ball.
Oh, the window.
The window.
Yes.
The broken window.
Yes.
That the replacement glass for the window was already in the house, and he was waiting for the contractor to fit it. So it's not that he just left it.
Well,
Would that fit in?
It does say that he made preparations to have it repaired.
Yes. His evidence was also in regard to the ladders that he had given an instruction to the contractor to lock it away.
So he was making precautions about ensuring the safety of the ladders.
Would that fit in with your diagnosis?
Well, my lady, I think one must remember that my diagnosis is not just made on one little factor, but is the grouping of all the factors. But certainly it would be something that he did to ensure safety.
Then you were asked, what if there were other versions of the event? Relevant to the shooting incident, there was only one witness, and that's Mr. Pistorius. So it's how you interpret his version. It's not that there's someone else coming to court and saying, that's not what happened, in fact, I saw the following.
Yes, there's only one witness.
Yes.
That's correct.
He also spoke about the effect of his mother's death. What I want to ask you, would it make any difference if it was not only the mother's death but also an absent father then? Not a father staying behind that would sort of take over the role of the mother,
yes,
as far as he could.
That is correct.
Would that play
his
a role?
primary attachment figure was his mother, so her death would have been very stressful, but he then had to depend on his siblings and his maternal aunt for emotional support.
Yeah. It was also put to you that you saw him after he had given evidence, and of course he's now anxious. Now, you've seen many people before they give evidence, and that anxiety in having to give evidence and to be cross-examined.
Yes.
Would that make a difference in this case, whether he's given evidence or must still give evidence?
No, it doesn't make a difference. Just being an accused in an offence is anxiety-provoking.
And then there was some reference to control in your report as a way to cope. How does that relate to protection? That person that builds in control.
You always want to keep your environment as secure as possible. And as far as you can control it, then you do. So you take extra care with preparations in order to ensure that you won't have increased levels of anxiety, to try and prevent those levels of anxiety going up even more.
It was also put to you that you have seen cases where persons with a post-traumatic stress order had been referred for observation, but was qualified to say those cases where there was an incapacity to appreciate between right and wrong or to act accordingly.
My lady, many individuals are referred for observation, and whether they're referred for observation for post-traumatic stress disorder or for other reasons doesn't necessarily mean that they'll be found to have that disorder affecting their ability to stand trial or their responsibility.
Now, then there was some cross-examination about the fact that the version to you was that he fired at a noise.
Yes.
I just want to give you his evidence in court. And that was when he was standing facing the toilet door, he heard a noise from the inside which he perceived to be person or persons coming out.
Yes.
And that's when the firing took place. So it's the noise precipitating the firing.
That's correct.
If you think about his version, to what extent would that be contradictory or in accordance?
From a psychiatric perspective, it doesn't make a difference.
Thank you, my lady. I have no further reaction.
Thank you very much. Any questions for the Thank you. Thank you very much, Dr. Foster, for your assistance. You may be excused.
Thank you, my lady.
May I please support,
Yes,
lady?
Mr.
I've indicated yesterday that I may bring an application. I'm ready to do so. May I be allowed the opportunity to do so?
Yes, yes.
I have prepared short heads of argument. May I hand that up, my lady? It's not comprehensive, but I hope it assists. My lady, may I have those copies back? I've handed the wrong copies to the court. I fixed some spelling errors with a pen. So I'll find that. These are the copies of the court. As could please, my lady, as I indicated yesterday, this application for the direction in terms of provisions of section 78. Lady, there will be a fairly lot of typing errors. I apologize. It was done in haste. It must read 78.1b, my lady. Read was 78.2 and section 79 of the Criminal Procedure Act. My lady, I will, in argument, expand on my heads as we've dealt with evidence this morning. In paragraph 2, we said that the defense called Dr. Foster. She's a well-known and respected psychiatrist. And the purpose of it, evidence was to present to the court psychiatric factors that may be of reference to conviction and sentence. During her evidence, my lady, she specified that the diagnosis was that the accused was suffering from GAD. She indicated yesterday, my lady, that her diagnosis is directly relevant to the accused's version and that, in her opinion, the GAD may have affected the accused's ability to act in accordance with an appreciation of the wrongfulness of his act. She said that at the end of cross-examination as well. She indicated in more particularity that GAD is a psychiatric disorder, that at least it's a psychiatric factor that impacted on the accused's ability to act in accordance with his understanding of wrongfulness. We say that GAD is listed in the Diagnostic and Statistical Manual of Mental Disorders. Then, my lady, Section 78 is clear. 78.2. May I read that? It reads, my lady, that if it's alleged at criminal proceedings that the accused is by reason of mental illness or mental defect or for any other reason not criminally responsible for the offence charged, or if it appears to the court at criminal proceedings that the accused might, for such a reason, not be so responsible, the court shall, in the case of an allegation or appearance of mental illness or mental defect, and may, in any other case, direct that the matter be inquired into and be reported on in accordance with the provisions of Section 79. But I will come to the definitions of mental illness and mental defect and any other issue. My lady, in bringing this application, we are mindful of the practical implications of such an application. We're mindful of the fact that, if granted, it may lead to a delay, extensive delay in the matter. My lady, we have taken into account the provisions of Section 78.1a and 78.1b, and we say, although the current defence team may indicate that they do not, it's never their intention that the GAD is part of the accused's defence or that a defence by the accused. The matter doesn't stop here. My lady, accused persons have in the past replaced their counsel, particularly when things go wrong. So what the views of the current defence team is concerned, although the court will take it into account, the facts before the court is of more importance, and the case law would bear that out. In all the cases that I will refer to, accused were legally represented by counsel in matters where they pleaded guilty, where courts asked counsel questions, but yet the court referred all those matters. And that is how seriously I say the Supreme Court of Appeal would view any allegation of the fact that it would affect the capacity of the accused. So we're saying, although we have counsel today, the matter doesn't end here. My lady, in the past, and I refer to those matters, the courts have, at the stage of sentencing or after pleas of guilty, referred accused for observation. My lady, it's an inescapable fact that the defence have elected to call Dr. Foster at this late stage. There's been no indication before Dr. Foster gave evidence of any psychiatric condition that may have affected the accused. If one has taken into account the plea agreement, it would indicate vulnerability, it may indicate the fact that the accused was anxious about crime, but so is everybody in this country. But the fact that it is a psychiatric diagnosis may play a role and must play a role, and that's what we base our application on. It only happened now, my lady. We had witnesses, 3 friends of the accused gave evidence, former girlfriend gave evidence. There's been no indication of abnormal anxiety that came forth. In fact, Mr. Roux reminded me the incident where people assaulted a taxi driver for somebody suffering from GAD must have been an unbelievable stressor. But he was able to control himself. But he was able to control himself there. An unbelievable stress. But yet, the defense calls a witness to indicate that GAD may have played a role on that particular day. And that is a decision based on the accused version only. Not on any other. So, my lady, that is what we base it on. My lady, may I refer to the case law and, my lady, will you allow me just to reach for my bag?
Please.
The first matter, my lady, that I wish to refer for is Mogorosi. Now, this matter has been referred to in all the cases that I would mention today, where the court indicated the test to be the accused might have been criminally responsible at the time he committed the offence. I italicise might to emphasise that a reasonable possibility suffices. It's not endowed with any discretion to refuse it. The court, my lady, and it's always difficult to indicate to a court that the court doesn't have a discretion. But all the cases would indicate that. May I refer the court to Mokim, my lady? The court indicated that if there's a reasonable possibility that the accused suffered from some mental illness or disorder, the court was under obligation to order an investigation in terms of Section 78(2) and 79 of the Criminal Procedure Act. And I stress, my lady, if there was a reasonable possibility, some mental illness or disorder. That's what was mentioned in this division. My lady, may I just deal with Moki? It's quite an important matter. In that matter, the accused was convicted and sentenced. The court, a quo, rejected his evidence. But on appeal, the appeal court decided to intervene, even with a credibility finding, because there was a reasonable possibility that he may have suffered from a mental illness. My lady, the court would know that the Court of Appeal would not intervene with credibility findings of a court of quo. So there was a big discussion in Moki about should the court interfere or not. If one reads Moki, my lady, it's an indication that it's so serious. If there's any indication of a mental illness of disorder, that the court would refer the accused. The accused has testified. Subsequent to his evidence, the psychiatrist drafted a report to bring certain psychiatric factors that were found to exist at the time of the commission of the offence to the attention of the court. She has conceded, my lady, that the diagnosis is relevant to his actions on the day. We mentioned that up until the time that she testified, the defence has not laid any basis of a defence in terms of Section 78. But the timing is significant. The timing of this evidence, my lady, should be taken into account by this court. When did this happen? It happened subsequent to the accused evidence. It happened subsequent to the accused experts giving evidence. My lady, the consultation happened after the evidence of the accused and after the evidence of the psychiatrist. Now, my lady, there must be a reason why that consultation would take place at that time. Now, the reason for that is, my lady, not saying is, let me rephrase, may later be seen to put factors before this court, and this court never gave it the necessary attention by referring. if we get to the appeal court later, there may be a question when it was clear that the psychiatric diagnosis may have affected the accused's actions on the day. Why did the court not do something? And, my lady, if this was part of the big case of the defense, if it was part of the intention to proceed, why did it happen then? Can it not be seen, my lady, as a fallback position? And because I don't understand why it happened then. And that should be significant. I mentioned in paragraph 12, my lady, there's been no suggestion of a general anxiety when 3 of his friends and former girlfriends testified. My lady, may I just amplify paragraph 11 by saying, we've had in this matter a defense of putative self-defense, which I thought during evidence in chief was adapted to one of I acted automatically. Now we have a witness being called by the defense saying the accused definitely did not act automatically or a state of automatism, but a psychiatric disorder may have played a role. Lady, if one is at this stage of a trial confronted by at least 3 defenses, then I say the court would err on the side of caution, expecting that there could be another defense raised. Even though, as I said, I don't think it happened here, I don't think a basis was laid, but, my lady, the fact that it changed would be red lights going on for this court, and for the court to act on the side of caution. My lady, we made a point that, and we put it to Professor Foster that, and we will argue, that the accused was not the most impressive witness. We will argue that his evidence be rejected. Isn't that then a reason why a psychiatrist is consulted after his evidence? If this has been the case of the defense from day one, it's unclear why the expert was only consulted then. That's why, my lady, we argue strongly that the timing of the witness being called and the timing of the consultations is important. My lady, the appeal court that was called in 1994, Mpeta, extended the inquiry. Again, my lady, it's a matter on appeal. This extended the matter for referral to instances where the accused may have suffered from reduced criminal capacity. Now, may I refer to that? The court on appeal, it was still the appeal division then, my lady. It was found the test whether procedure in terms of section 78.2 must be adopted is whether there is a reasonable possibility, in the light of an objective consideration of all the information before the court, that the accused is not criminally responsible or that he suffered from reduced criminal capacity. So the appeal court even extended it to reduced criminal capacity. Lady, that goes further because one will have to take into account what Dr. Foster said. She said the intention was to put psychiatric factors before the court so that the court could take into account for conviction, was her words, and sentence. My lady, Mr. Roux is correct that 78.7 in the Criminal Procedure Act deals with diminished responsibility. And there is an indication that diminished responsibility will be taken into account at sentence stage. But it's still part of the same trial, my lady. And the appeal court has extended, or let me not use the word extend. The appeal court has referred a matter back for evaluation, taking into account that the accused may have suffered from reduced criminal capacity. Lady, as far as the definitions of mental illness and of mental defect are concerned, lady, there's no definition in the Act, the Criminal Procedure Act. I've had opportunity to consult other handbooks, psycholegal assessment in South Africa. I couldn't find a definition, but what I could find, my lady, was the Supreme Court of Appeals view of what is meant by mental illness and or mental defect. And that is in the matter of Mabena, which I've quoted there, my lady, at paragraph 482. My lady, at page 489, paragraph 16.
482, 489.
At 489, my lady, 489. The matter starts at 482, but at 489, my lady, at paragraph 16.
Thank you.
The SCA mentioned that mental illness or mental defect are morbid disorders that are not capable of being diagnosed by a lay court without the guidance of expert psychiatric evidence. An inquiry into the mental state of an accused person that is embarked upon without such guidance is bound to be directionless and futile. And then the court just carries on by describing what happened in that particular case. Now, my lady, what we have an indication of the defense saying, on our version, on the accused versions, which we don't know which version was used, there is an indication that a psychiatric factor or psychiatric disorder may have played a role. If that is so, my lady, it's a matter to be referred for the court also to gain the views of experts that have a global view of the case, of all the evidence, and not only one version. Because at the moment, my lady, we have a psychiatric factor may have impacted on his version. And that does not suffice. We deal, my lady, at page 16 with the fact that the accused has now furnished us with 3 versions. At this stage, my lady, we say that certainly the court is entitled to know what the accused's defense is. We know that Mr. Roux was at pains in re-examination to indicate that it's not the doctor's view that the accused is suffering from a mental illness. But, my lady, it's good for the doctor to say that, and she is an expert. But, my lady, the fact says she indicated that a psychiatric diagnosis may have affected. As it stands now, my lady, and I'm sure that would be Mr. Roux's argument, as it stands now, Mr. Roux would say that he never laid a basis for Section 78 to be his defense. But, my lady, where we cannot get away from is that, based on the evidence, at least Mr. Roux will not argue that they are abandoning diminished responsibility. that should not be taken into account. And if that is so, my lady, then the appeal court, and it's not only in that matter, it was also in the matter of Sindani, my lady, where the appeal court decided to refer a matter back for evaluation based on the fact that the accused may have suffered or there may have been diminished responsibility. We've referred to the Sindani matter in the record, so it's not only in the one matter. My lady, in paragraph 17, we discussed the fact that Dr. Foster argued that the accused is a danger to society and himself that should not be allowed to possess a firearm. Now, my lady, the mere fact that she's indicating that he's a danger and should not have been a firearm goes towards his mental state. And as soon as that happens, my lady, it's not our argument that we say we have proven a mental illness now. We're saying that if there's a reasonable possibility, if there's an indication, and I will refer to case law, my lady, if there's just an indication, then the court does not have discretion. But if I'm wrong.
When you say indication, you said two things. You said indication and you said reasonable possibility.
Yes.
It can't be one and the same thing.
May I refer to, my lady, may I refer to case law? And I just want to open it and see how the courts described it. Now, my lord, in Mogorosi, at 942 A to C, the court said, the question remains the same. Should it have appeared to the court a quo that the accused might not have been criminally responsible at the time he committed the offence? I italicize might to emphasize that a reasonable possibility suffices to oblige the court to do a direct inquiry. So, my lady, that includes both. If there's indication, so if it might have, then that should be taken into account as a reasonable possibility. That's what the court said. The onus is on the accused to prove at this stage that he was in fact not criminally responsible for the offences. And then it goes on, my lady, and it says it's not endowed with any discretion to refuse it. And if it does refuse it, that's what the appeal court said, this court can therefore interfere and itself direct the inquiry. Well, my lady, and also in Mogorosi, it indicates that the court may make an order in terms of Section 78(2) at any stage during the proceedings. So, my lady, that is the test. As low as that. In Sindani, my lady, the court indicated that the test is a low one. I just referred to that particular matter. It says, my lady, in Sindani, the Appellate Division, test for referral of accused for observation in terms of Section 79 is a low one. Sufficient in cases such as the instant if reasonable possibility is shown that the order for referral in terms of Section 79 would ultimately be granted. That should be seen in context, my lady. It's always at the appeal court stage. I couldn't find any other case law. But the case law I found was in the extreme circumstances, my lady, where the appeal court would refer it back. So the appeal court indicated that because the test for referral in terms of Section 79 is a low one, therefore the appeal court would be able to interfere. Because all the appeal court would have to ask itself, is there a reasonable possibility that the accused would have succeeded or that the court should have done it? But, my lady, The court also said in Sandani, my lady, that the court remarked that an investigation in terms of Section 79 of the Act was far more comprehensive than the examinations undertaken by a psychiatrist, a psychiatrist that gave evidence, and that they could not adequately serve as a substitute for the inquiry. In this particular matter, they called psychiatrists to make a finding there and then, but there was no referral. And the court said the test for referral is a low one. So, my lady, I think I was at page 17. There, my lady, what we have here is the fact that we're saying that it's a psychiatric diagnosis. We say that in terms of the definition that psychiatric diagnosis and a psychiatric disorder was seen by the appeal court by including disorders. We're saying that in terms of definition in Petla, it complies. And we're saying further, my lady, that Dr. Foster referred to the fact of the accused vulnerability as well. So it falls 100% in the definition of mental illness and or either other factor that may have played a role at the time of the offence. So, my lady, if there's any other matter which we have in this case, which Dr. Foster testified to, then, my lady, that would be a further motivation for this court to refer this matter. My lady, we've now had evidence that GAD may have played a role. It is in the interest of justice, I say, but that in itself indicates that there's a reasonable possibility that psychiatric factors, which is a mental illness, may have played a role. If that is a finding, my lady, then the accused should be referred. My lady, may I just read something that was just handed to me? Yes, my lady, the process in terms of Section 79 that would be followed is that, apart from all the different psychiatrists that would be appointed, is for the panel to make a finding if a psychiatric condition existed at the time, and if the psychiatric condition and or mental illness that existed at the time played a role in the commission of the offence, and to what extent. We just don't have that. It may be argued by the defence at the end of the case, may be argued by the state at the end of the case, but, my lady, the risk that the defence took in calling Dr. Foster at this stage of the trial has already indicated that there's a reasonable possibility that it may. My lady, I'm not saying it did. If the court would ask me a direct question, if I think it played a role, the answer would be no, my lady. And I would argue that. I'm not saying that I did. I'm saying, my lady, that this is not the end of the matter. That 78 has got a low threshold, and the court should act in terms of that.
Did you find a case which is directly in point where the accused says, I'm normal, there's nothing wrong with me?
I didn't find a case in point.
You couldn't find it.
No.
In a case of this nature, where is the onus?
It is on defence.
It's on the defence.
Yeah. No, indeed. That's what I referred. The onus is on the defence, but, my lady, although the onus is on defence, the defence in the Moki matter, and if one reads those cases, in the Moki matter, there was only leave to appeal granted on sentence. The counsel acting for the accused did not even ask leave to appeal on the merits of the matter. Counsel Therefore, the Court of Appeal could have accepted that it's not his case. But what happened there, on appeal, the court said that the court is obliged to look at it. So it was never mentioned, my lady, not even on appeal. It was not mentioned during the merits of the case. It was not a factor. There was no appeal against the conviction, so it was never mentioned there. The mere fact that an accused said, I took a knife and I can't remember what happened after that, and then he killed his wife. That in itself was taken by the appeal court to interfere. So, my lady, my argument is that the accused should be referred. My argument is that also that at this stage of the trial, having received the evidence that the court did, that the court should give effect to that evidence and apply its mind to the possibility of what might happen to the evidence in future. But my lady, no, I did not. The closest I got is Moki. Moki did not have leave to appeal and did not use his mental capacity at all. That's my argument.
Thank you. Thank you very much. Yes, Mr. Rowe?
My lady, and I say it with great deference, Mr. Nell's reading of the law reports is rather unfortunate. He says to you, he makes the submission that it would suffice to have an indication. Can I read the law to you? And the case that he refers to, and I will also refer to, he refers to the Maharosi case, page 9. I'm going to read to you the actual approach, not the indication as submitted. The court says the following, dealing with this type of argument. It says the following. It says, but in my view, nothing turns on that. For section 78.2 does not mean that the mere making of such an allegation per se obliges the court to direct the inquiry. That would be manifestly absurd. Although the conjunction or is used in the subsection to link the two requisites, I think that it's also used conjunctively in this sense. If such an allegation is made, it must also appear to the court before it can direct the inquiry that the accused might not be criminally responsible for the offences charged, i.e. that there is some substance in the allegation. And he refers to the other cases, but it says there must be substance in the allegation. Exactly the same approach was followed in the appeal court in Makoba. That's not in his heads. It's 1979, 3, all South African law reports, 714A. It's 1979, 3, all South African reports, 714A, or a different citation, 1979, volume 2, South African law reports at page 93, where it says the allegation must be supported by grounds. It's not a mere indication. And I think what's maybe on law confusing to the state, with respect, maybe the words where it says in sub 2, 78.2, if it's alleged, and we know what it alleged means, it alleged on proper grounds. That in criminal proceedings that the accused is by reason of mental illness or mental defect or for any other reason not criminally responsible for the offence charge, or if it appears to the court. And it says it must be read conjunctively. So the court would look at this person, would see, or to the facts and see, but there's something wrong. And I'm going to take you to the cases quoted by the state to show you there's something wrong. In the Maharosi case, the allegation was made, but the court said there was no substance. You can't just allege it. That's the state's case. In the Moki case, the person said, I had enough and I can't remember. Now, it's screaming out that it's either a mental case or a sane automatism. And I'm surprised that the court, I quote, did not refer. So there was a duty on the court, because it obviously appeared to the court that this man did not know what was going on. He says that's his case, that he did not know, he can't tell you what happened. So there's substance. In the Sindane case that the state relied on, this man was in Westkoppies. He was a Westkoppies patient. So it's not a person, an everyday person. So his reference to the cases are interesting. But all those cases don't support the state. What does the state do? The state wants a second opinion. He wants the court to assist the court in giving a second opinion. And he says that, the very last paragraph. The court ought to therefore be given the benefit of a second opinion. It's not the court. The state wants a second opinion through a very strange procedure. So we can see the motive. It's quite clear. But let us look at the facts. The first question that the court must answer in deciding the matter is, was there an allegation made supported by facts? The state accepts the expertise of Dr. Foster. She makes it plain and clear, and I've referred you to her evidence. She says, that is not my allegation. And maybe to pinpoint it, she says, at the record handed up to you, it's the real-time record, she was asked right in the beginning about it. She says, cross-examination. It starts like this, page 3986. Cross-examination by Mr. Nell. Dr. Foster, and I quote, let me first start by saying that the fact that you diagnosed an anxiety disorder, are you saying that that affected his ability at the time of the incident to distinguish between right and wrong? Answer, no, not at all. Mr. Nell, are you saying that it affected his ability to act in accordance with his understanding of right and wrong? No, I'm not saying that, my lady. And then she carries on to repeat it and repeat it and repeat it. And again saying, it's for the court to find. And of course it's for the court to look at the facts. And I say, of course, if you find paranoid or it's delusional, and you take then this disorder, we see the extreme of this disorder. And then it's for the court to say, it appears to me, on the facts available, that this is a matter that should be further investigated by making use of this procedure. But she then makes it plain and clear. She says, he's not delusional and he's not paranoid. I specifically looked at that. And it was in evidence in chief, and it was dealt again in evidence in reply. So, A, the state is wrong with respect by telling you it must only be an indication. B, the state is wrong by relying on these cases because each case has a history crying out for referral. C, the factual basis does not support the state, and it's just a ruse with respect in order to get a second opinion. Whether that's good or bad, that's irrelevant. And it's simply going nowhere. Where's the state's evidence? To say, I have a psychiatrist, and I will call a psychiatrist, and this is what it is. He's simply trying to suggest, if you look at all the cross-examination, he's trying to suggest to Dr. Foster that it's a 78. And again, he makes the mistake. He makes the mistake by referring to a psychiatric condition and saying, but that's a mental disorder. It may or may not be. But that's not the test. And if I may read the test again, it says in 78.1, a person who commits an act or makes an omission which constitutes an offence, and who at the time of such commission or omission, 1, suffers from a mental illness or mental defect, 2, which makes him or her incapable of appreciating the wrongfulness of his or her act or omission, or of acting in accordance with such an appreciation of wrongfulness. So you can't just say generalized anxiety disorder is a mental disorder. And I may say, by the by, if you look at DSM-5, it's just defined as a disorder. It doesn't refer to mental disorder. But not important. Make it a mental disorder. You need the second leg to say that that influenced that, and that must then be alleged on proper grounds, and it says a sort of conjuncture, must appear to the court. And the appearance to the court, I've alluded to that, where the court would look at the record on appeal and say, what's going on in this case? The man then is telling the court that he had a knife and the next moment the person was dead and he can't explain it. There's something wrong. You need facts, and that's a typical example of appear to the court. So, if I may just look at a note. Yes, I'm just referred to further authority to say, in Infra, to say that's a value judgment, and I think that's true. It's a value judgment that the court must make, but it must come from an allegation supported by facts and an appearance to the court on the facts available. And all that this witness, Dr. Foster, was doing, and quite correctly, because you may not usurp the powers of the court. It is not for a psychiatrist to suggest a consideration of the facts. All that she was doing, and very correctly so, to say, this is what I say. I'm not making the allegation. But insofar as the court's finding on the facts, if the court finds on the facts that that is so, yes, then it's fine. But it's not my case. It's not what I'm saying. And it's also not the defense case. So the question would rather be, is it in something standing out to the court that would appear to the court that there was this difficulty that would warrant a reference to a 30-day observation? And there's nothing. The state did not say that. The state simply worked on an indication, trying to get an indication by virtue of wanting a witness to say that. That's simply not good enough. You asked a question, and before I deal with the onus, I think with great respect, my lady, you absolutely, in debate, summed up the position. I want to show you where it is. At page 4007 and the top of 4008, after I'd addressed you, you asked a question. In other words, you're saying it's not an allegation, because it's not. And it must not only be an allegation, it's an allegation supported by facts. We know what the AD said about this. And the court correctly said, again, court, there must be an allegation first. Absolutely, my lady, that's why I object. So it's absolutely a correct summary of the approach to be followed. But for the fact that that allegation must not be a mere allegation. It was one according to the two cases that I referred to, the Macharosi case and the Makhoba case. It must be an allegation supported by facts. The other instance, of course, in the case of an appearance, we've seen the example used by the state. That's the Moki one, where the court would look at the record, would look at the evidence and would say, but hang on, I'm not comfortable. I am not comfortable. I see enough substance that would dictate to me that there may be an incapacity to distinguish between right and wrong, or to act accordingly, or both of them. That's what happened in the Moki case. What the state then does, my lady, is to go to three different versions. I think he usurps the power. Or he may say, I will address the court on that. That's irrelevant. That's irrelevant. And counsel would only do that when you know that your case is not good enough on what you argue. Now you have to go to the emotion, say, but he's a liar in any event, and how do you know now what he's saying? Now, does the state say on any of the three versions that's in dispute? Does it say that any one of that has as its substance an inability to appreciate or inability to act according? No. It's simply, there are no three versions, and I was asking myself, what is the relevance of that? What is the relevance of that? Then it goes to automatism. the defense is not automatism, sane automatism, and Dr. Foster quite correctly say, no, I cannot find anything suggesting automatism. And why is that relevant? That is relevant if you look with respect at section 70. 8.2, it was amended. And it was amended following certain decisions by the court, like Gazaldo, where it was sane automatism, and that sane automatism was not put in the bracket of section 78. And then the defense would come with the defense at a late stage, or at any stage of sane automatism, and the state was sort of in a predicament with that. And then the legislature, in its wisdom, decided to say, while on those other causes, like the sane automatism, I would give the court a discretion. In a mental disorder, having the consequence of an incapacity to appreciate or to act accordingly, the court must, but of course in other cases such as a sane automatism, it gives to the court a discretion, it says, and may in any other case direct that the matter be inquired into. And that typically came, it found its way into the law book because of the sane automatism cases, where the legislature then decided, well, let's give at least to the court something to stand on to say, well, in that case, I'm not just going to accept what you say, I have a discretion. That's where it comes from. It's not here. It is disavowed by the witness, called by the defense. It is definitely not the case. There is a second problem. So apart from the fact that there's no merit, I must point out to the court that we're calling a further witness. And that further witness would talk about the flight and the fight syndrome and the vulnerability of disability. Not related to Section 78, but in any event, even if there's a question mark in the court's mind, where there should not be, there's another witness coming, it's premature. Because then, what does that witness say? And then he comes to give evidence and take him back again. He's now there for 30 days on that one disorder alleged, bring him back, and then we send him back for 30 days on the next part of it, because that witness must still come that's going to give evidence. So apart from the absence of merits, it's a premature application. And the state's welcome to repeat the application after that witness dealing with that aspect. Otherwise, my lady, we're going nowhere. But the main argument is there's no merit. And I'm going to repeat myself. There is no merit. The second argument is, should the court find that there is some merit, then it's inopportune, it's not the appropriate time, because I informed the court that another witness will be called to deal with the second aspect. And what you can't do as a 30-day, come back and have another 30 days. It would just not be appropriate in a case. But we submit, my lady, that for the moment we must take emotions out of it, how many versions and whatever the address would be. And it's simply a case we talk, and that is what Dr. Foster is saying, and that's all she's saying to the court. When you look at the facts, you consider all the evidence in assessing his evidence and deciding what the true facts of the case are. That's all you do. We're not saying to you that we want you to introduce a finding that he was incapable in the 2 points, one between right and wrong, or to act accordingly. That's not the case. That's not the witness. But we say you take factors into account. It's like in any other case. It's like in a self-defense case. The court must take factors into account where you bring evidence that it's a sickly person, where you bring evidence that that person cannot lift his left arm. The court will take that into account in the court's analysis of the evidence and then find it's applicable or find that it's not applicable. But that has nothing to do and nothing in common with a mental illness relevant to an incapacity as defined in the Act. So we say there's no merit in the application. Alternatively, in any event, there's a second witness coming in, it's premature. Thank you, my lady.
So we're going to deal with the onus.
Oh, I apologize. Yes, my lady. The onus, it was submitted that the defense has the onus. It's not absolutely correct. If I may just read to you, it's also a new insertion into the Act. There are 3 points that are important there. The first is this. It's section 1 capital A that was inserted, the same time when the other courses were inserted. It says every person is presumed not to suffer from a mental illness or mental defect so as not to be criminally responsible in terms of section 78 until the contrary is proved on a balance of probabilities. Now, that is just a cold fact that you take into account. It's not at the end of the case where you would have prominence. It hasn't got that prominence right now, but it's a factor that you will take into account and say, I must also bear in mind when I look at an allegation, when I look whether it's an allegation on proper grounds, I must also factor into that consideration the presumption of that it's not. The second thing that you must do, it says, and that's also inserted 1 capital B, it says whenever the criminal responsibility of an accused with reference to the commission of an act or omission which constitutes an offence is in issue, the burden of proof with reference to criminal responsibility of the accused shall be on the party who raises the issue. We don't raise it. We do not raise it. So to say that that onus is in the defence, that is not correct. There's been an amendment to the Act. It shall be on the party who raises the issue. Thank you, Madam.
Thank you. Thank you. Yes, Mr. Nel?
May it please the court, my lady, one thing I will agree with Mr. Roo, and that's that we should not be emotional. There I agree. My lady, it's one thing for counsel to, in 2 minutes, read a case that the state has referred to and tell the court that the state doesn't know what they're doing in referring to the matter. My lady, I have to mention that in the Moki matter, it's a 1991, but the counsel in that matter was G.C. Nell. That was me. I know this case by heart, my lady. I know exactly what happened. I was counsel there. I, in fact, was arguing for the matter not to be referred as Mr. Roo is doing now, in that particular matter. I lost. My lady, if Mr. Roo would get up and argue and say that the way we refer to matters is unfortunate, it's there for the court to read, my lady. We mention the matters, we quote from the cases, and I stand by what I have quoted and what I've argued. That's the one aspect. The other aspect, my lady, to the argument about I will call another witness is, let me use the word unfortunate. So the fact that there will be another witness would hold this court to ransom. But when Mr. Roo said, and that's significant, he said, I will call a witness and perhaps the state will feel exactly the same way they're doing now. They could then bring the same application. That, my lady, was for me the clearest indication that we're on the right track. I'm not bringing this application. I would also be as emotional if I called a witness and that witness left open the door for the referral of my client. That's what happened, my lady. Now, my lady, if Mr. Roo's saying, I'm going to do this again, or almost the same thing, that is the clearest indication, my lady, that the court should refer it now. Because that is what the court said by mental illness, mental defect, or any other. If there will be other, it will also then form part of the panel. But, my lady, I didn't want to respond to...
And where would you place this? You're placing it under mental illness, mental defect, or any other reason?
Mental illness, my lady.
Mental illness?
Yes, ma'am.
Where do you get that?
From the definition of Mpehla, the fact that it's a
From the definition of?
Mpehla, my lady.
Yes.
That it's difficult to define. If an expert indicates that it's a disorder, it could be a mental illness, and that's my argument. There's no definition. So, my lady, if there's no definition, then it's in the hands of the court to decide. But what we have is, we have the fact that it's a psychiatric disorder, and that's listed in the DSM. cautionary rule or not, it's listed in the DSM. The witness gave evidence that it's a psychiatric disorder. My lady, to ask me, and I say it with the utmost respect, if it's a mental illness or not without the definition for mental illness is difficult. I have to explain why I say that. Now, if I use Mpetla, Judge Nugent's explanation for mental illness and mental defect, he indicated that, and I think I've quoted it in their heads. No, I haven't. Let me just quote it again. Oh, no, I'm wrong. Mabena. If I said in Petla, I'm wrong. I'm referring to Mabena. I apologize. I'm referring to Mabena. Mental illness and mental defect are morbid disorders that are not capable of being diagnosed by a lay court without guidance of expert psychiatric evidence. Now, my lady, I asked the witness to be able to diagnose GAD. That's a psychiatric diagnosis. Said yes. So, and psychiatrists would make that diagnosis. She said yes. Now, if that is so, and this is the only definition I could get, then certainly I'm referring to a mental illness. Judge Nugent said, mental illness and mental defects are morbid disorders that are not capable of being diagnosed by a lay court without guidance of expert psychiatric evidence. Then it must, by inferential reasoning, Malay, be a mental disorder, because we don't have a definition for it. But where I differ from Mr. Roux, and where I say I'm correct on the case law, if there's a reasonable possibility that it existed, the court does not have an onus. Now, my lady, if there is a reasonable possibility that it falls within the definition, it's exactly the same thing. Because, my lady, with the utmost respect, and I haven't heard Mr. Roux giving an argument on mental illness. If there's no definition for mental illness, I cannot tell the court if it's a mental illness or not. What I can tell the court is a mental illness is a condition that only psychiatrists could define after evaluation. That's what Judge Nugent said in the SCA. And if that is so, then it's a mental illness. My lady, and then, if it's a mental... My lady, I will go so far as to say that my biggest hurdle would be to bring whatever happened here into the definition of mental illness. If I do that, with the utmost respect, if I convince the court that the evidence of the doctor referred to a mental illness, it's the end of my argument. The court shall, with the utmost respect. And, my lady, I think I've done that by the definition that the SCA has put forward. My lady, when there's argument about delusions and paranoia, that's not the reason for the referral. We're not looking for that. We're looking for what we're not looking for. We're reacting on the evidence of a defense witness saying, I diagnosed a psychiatric disorder that may have played a role in terms of 78(1)B. That's the end of it. And if that's a mental illness, that's the end of it. She also indicated, my lady, that she links the GAD with the physical disability of the accused, which is a psychological factor. Now, that is, in my understanding of what I've read, if there's psychiatric and psychological factors, that would be taken up by the word other. Mental illness, mental defect, and any other. Any other would very well be psychological factors that we have in this matter. Lady, We started off by saying, I'm only bringing this application to apply the law as it's been applied over years, in terms of a reasonable possibility that the accused suffered from some mental defect. The court is then cautioned by all the case law to act decisively and not wait till it gets to appeal. So that's what we're acting on. We've never, in our case, presented a case that there's some mental defect. Not at all. And we will not. But there's now, by a defense witness, evidence before the court, and the court must act. That's our argument. But my lady, I stand by the cases that I've referred to. And I'm sure the court would read them. I think it's unfair. But that would, at least as far as the tests are concerned, and in Moki's matter, as far as the facts are concerned, support my argument 100% as a court basis. That's my argument.
Thank you. I'd like to...
If I might just give you the page, that's all. I'm just assisting the court. I don't want the second bite at the cherry. In the Mabena case, I would just ask the court to read 488, page 488, to see what the full definition is, not only mental order, but also incapacity. It's dealt with page 488.
Thank you very much. I'll be back with the decision tomorrow at 9:30.
That's a good basis.
Emila, dan meneer op, lijst die kort toegemaakt.